This court deed proves this is my property. You need to stop this construction immediately. You are trespassing. You cannot just build here. This is unacceptable. I demand you stop this construction right now.
Ma'am, you need to calm down or I will have to remove you.
Imagine waking up one morning, pouring your coffee, stepping out onto your back porch, and realizing that 96 families are living on land that belongs to you. That is exactly what happened to me. And when I tried to tell them, when I tried to show them the proof, they laughed in my face. The HOA president told me I was delusional. The board members threatened me with fines. A lawyer sent me a cease and desist letter telling me to stop making false claims. But here's the thing about the truth. It does not care who believes it. It does not care how powerful you think you are. And when I walked into that courtroom with a deed that was over 100 years old, every single person in that room went silent. This is the story of how I took on an entire homeowners association, how they tried to destroy me, and how the truth set me free. My name is Daniel Mercer. I grew up in a small town in eastern North Carolina called Harlow Creek. It was the kind of place where everybody knew everybody. My family had been in Harlow Creek for generations. My great-great-grandfather, Elijah Mercer, had purchased a large parcel of land back in 1902. It was a beautiful piece of property. Rolling hills, a creek that ran through the middle, and old oak trees that had been standing since before the Civil War. Over the decades, the family held on to that land. Some of it was farmed. Some of it was used for timber, and some of it just sat there, quiet and untouched. Waiting, my grandfather, Thomas Mercer, inherited the land from his father. He was a proud man. He worked that land with his own 2 hands. He raised cattle. He grew tobacco. He built a small farmhouse right in the center of the property. When I was a boy, I used to spend my summers there. I would run through the fields, catch crawfish in the creek, and sit on the porch while my grandfather told me stories about our family. He always said the same thing. This land is who we are, Daniel. Do not ever let anyone take it from you. I promised him I would not. I had no idea how hard I would have to fight to keep that promise. My grandfather passed away in 2004. It was the hardest day of my life. He left the land to my father, and my father, who had moved to Charlotte for work, did not have much use for it. He paid the property taxes every year, kept the farmhouse maintained, and drove out once or twice a year to check on things. When my father passed away in 2016, he left everything to me. The house in Charlotte, his savings, and most importantly, the land in Harlow Creek, all 147 acres of it. I will be honest with you. When I inherited the land, I was not in a position to do much with it. I was going through a divorce. I had 2 kids to take care of. I was working 60 hours a week as an electrician. The land was 3 hours away from where I lived, and I just did not have the time or the energy to deal with it. So I did what my father had done. I paid the taxes. I kept the farmhouse insured. And I told myself that one day when things settled down, I would go back and figure out what to do with it. That one day did not come for almost 5 years. It was March of 2021 when I finally made the drive back to Harlow Creek. My kids were with their mother for spring break. I had a few days off work. I thought I would go check on the farmhouse, maybe do some repairs and just breathe some fresh air. The drive was peaceful. The closer I got to Harlow Creek, the more I felt like I was coming home. But when I turned onto the old county road that led to our property, something felt wrong. The road had been paved. It used to be gravel. And there were new street signs. Street signs that had not been there before. I kept driving and my stomach started to twist. Where there used to be open fields, there were now houses. Not 1 or 2 houses. Rows of houses, cul-de-sacs, driveways, mailboxes, manicured lawns. A neighborhood. An entire neighborhood had appeared where my family's land used to be. I pulled over to the side of the road and just stared. My hands were shaking. I could not process what I was seeing. There was a large stone sign at the entrance of the development. It read Oakwood Estates, a premier community. It's managed by the Oakwood Estates Homeowners Association. I drove further, trying to find the farmhouse. It was gone. The old oak trees, gone. The creek had been redirected through a concrete drainage channel. Everything my grandfather had built, everything my family had loved, had been erased and replaced with cookie-cutter homes and a community clubhouse. I felt like I was going to be sick. I sat in my truck for 20 minutes, trying to understand what had happened. Then I got out and started walking. I walked up to one of the houses and knocked on the door. A woman answered. She looked at me like I was a stranger, which I suppose I was. I asked her how long she had lived there. She said 3 years. I asked her who had built the development. She said a company called Ridgeline Development Group. I asked her if she knew who owned the land before the houses were built. She had no idea. She said she bought the house from a realtor and assumed everything was legitimate. I thanked her and walked away, my mind racing. I drove straight to the county courthouse. I needed to see the property records. I needed to understand how someone could build an entire neighborhood on land that belonged to my family. The clerk at the records office was helpful. She pulled up the parcel information for the land in question, and what I found made my blood run cold. According to the county records, the land had been transferred in 2017 to a company called Ridgeline Development Group through a tax sale. Here is where things get infuriating. I had been paying the property taxes on that land every single year. I had receipts. I had bank statements. There was no delinquency. There was no missed payment. But according to the county records, there had been a tax lien placed on the property in 2016 for unpaid taxes. The lien was supposedly for a period when my father was still alive. But my father had paid those taxes. I had the proof. Someone had either fabricated the lien or manipulated the records. And based on that fraudulent lien, the county had held a tax sale, and Ridgeline Development Group had purchased the land for pennies on the dollar. I started doing research on Ridgeline Development Group. It was a limited liability company registered in the state. The registered agent was a man named Victor Hargrove. I looked him up. Victor Hargrove was a real estate developer based in Raleigh. He had built several subdivisions across eastern North Carolina. But here's the interesting part. When I dug deeper, I found that Victor Hargrove's business partner was a man named Carl Jennings. And Carl Jennings happened to be the county tax assessor at the time. The fraudulent lien was placed on my property. Let me spell it out for you. The county tax assessor, Carl Jennings, had fabricated a tax lien on my family's property. He then arranged for the property to be sold at a tax sale to a development company owned by his business partner. They stole 147 acres of land from my family, built 96 homes on it, and sold those homes to unsuspecting buyers. The whole thing was a scam, and they had gotten away with it for years because nobody was watching. Nobody was checking. Nobody cared about some family's old farm out in the country. I called every lawyer I could find. Most of them did not want to touch the case. They said it was too complicated. They said it would take years. They said the cost of litigation would be enormous. One lawyer told me bluntly that I was fighting a losing battle because the homes were already built and families were already living in them. You cannot just tear down 96 houses, he said. But I was not trying to tear down houses. I was trying to get justice after weeks of searching. Found a lawyer named Patricia Owens. She was a property rights attorney in Raleigh. She had a reputation for taking on difficult cases. When I sat down in her office and laid everything out on the table, the deed, the tax receipts, the fraudulent lien, the connection between Carl Jennings and Victor Hargrove, she leaned back in her chair and said, "Mr. Mercer, this is one of the most clear-cut cases of land theft I have ever seen." She took my case on a contingency basis. That meant she would not get paid unless we won. The cornerstone of our case was the original deed. My grandfather had kept it in a fireproof safe in the farmhouse. When the farmhouse was demolished, I assumed it was gone. But my father, God bless him, had taken the deed out of the safe years ago and stored it in a safety deposit box at a bank in Charlotte. I had the key. I had just never opened the box. When I finally did, there it was. The original deed from 1902, signed by Elijah Mercer, with the official county seal. The legal description of the property and the full chain of title going back over a century, it was pristine. It was undeniable, and it proved beyond any shadow of a doubt that my family owned that land. Patricia spent months building the case. She hired a surveyor to confirm the property boundaries. She obtained certified copies of every tax payment my family had ever made. She subpoenaed the county records related to the tax lien and the tax sale. She uncovered emails between Carl Jennings and Victor Hargrove that showed they had been planning the scheme for over a year before the lien was filed. She even found a whistleblower inside the county assessor's office who was willing to testify that Jennings had manipulated the records. While we were building our case, I made the mistake of trying to talk to the Oakwood Estates Homeowners Association. I thought maybe if I explained the situation, they would understand. Maybe they would work with me. Maybe we could find a resolution without going to court. I was wrong. I sent a letter to the HOA board explaining who I was, presenting a copy of my deed, and asking for a meeting. The response I got was not a meeting invitation. It was a cease and desist letter from the HOA's attorney. The letter was aggressive. It accused me of attempting to perpetrate a fraud on the homeowners of Oakwood Estates. It said that my claims were baseless and without merit. It threatened me with legal action if I continued to harass the residents or make false claims about the ownership of the property. It was signed by an attorney named Richard Davenport, who represented the HOA. I showed the letter to Patricia. She smiled and said, "Good. Now they know we are coming." In September of 2021, I filed a lawsuit in the Superior Court of the county. The defendants were Ridgeline Development Group, Victor Hargrove, Carl Jennings, the county, and the Oakwood Estates Homeowners Association. The complaint alleged fraud, conspiracy, wrongful conversion of property, and violation of my constitutional rights. We sought the return of the property, compensatory damages, and punitive damages. The filing made the local news, and that is when things really started to get ugly. The residents of Oakwood Estates were terrified. They had purchased their homes in good faith. They had mortgages. They had children in school, and now some stranger was claiming that their entire neighborhood was built on stolen land. I understood their fear. I truly did. But their anger was directed at the wrong person. Instead of being angry at the people who had stolen my land and sold them houses on property that was not theirs to sell, they were angry at me. I started receiving threatening phone calls. My truck was vandalized when I drove through the neighborhood. Someone even posted my home address online with a message that said, "This is the man trying to take your homes." The HOA launched a full-scale war against me. They hired a public relations firm to discredit me. They held community meetings where they told residents that my lawsuit was a shakedown. Richard Davenport, their attorney, went on local television and called my deed a worthless piece of old paper. He said that the tax sale had been conducted lawfully and that I had no legal standing. He was smooth. He was confident. And he was dead wrong. The local media picked up the story, and it spread fast. I was interviewed by a reporter from the county newspaper. I told my side of the story. I showed them copies of the deed, the tax receipts, and the evidence of fraud. The article went viral. People from all over the country reached out to me. Some offered support. Some called me a liar. Some just wanted to know what was going to happen next. I did not care about the attention. I cared about getting my land back. The discovery phase of the lawsuit was brutal. We exchanged thousands of documents. We took depositions from Carl Jennings, Victor Hargrove, the county clerk, the HOA board members, and a dozen other witnesses. Carl Jennings was the most interesting deposition. When Patricia asked him point blank whether he had fabricated the tax lien, he invoked his Fifth Amendment right against self-incrimination. That told us everything we needed to know. Victor Hargrove was more talkative, but his story was full of holes. He claimed he had purchased the land at a legitimate tax sale and had no knowledge that the lien was fraudulent. But when Patricia showed him the emails between him and Jennings, emails where they discussed the Mercer property months before the lien was even filed, he started to sweat. He stumbled over his words. He contradicted himself. His own attorney kept objecting, but the damage was done. The HOA board members were a different story. They genuinely did not know about the fraud. They had purchased their homes from Ridgeline Development Group through legitimate real estate transactions. They had title insurance. They had closing documents. They believed everything was above board. And in a way, They were victims too. But that did not change the fact that their homes were sitting on my land, and someone was going to have to answer for that. The county tried to distance itself from Carl Jennings. They released a statement saying that Jennings had acted alone and that his actions did not represent the county. They fired him from his position, which he had somehow managed to keep even after the lawsuit was filed. But Patricia was not going to let the county off the hook. She argued that the county had a duty to verify the accuracy of tax liens before conducting tax sales, and that their failure to do so made them liable. Before the trial, there were settlement offers. Ridgeline Development Group offered me $2 million to drop the case. The HOA offered me $500,000. The county offered me $1 million. Patricia advised me to consider the offers carefully. Combined, it was $3.5 million. That was more money than I had ever seen in my life. But the land was worth far more than that. The 96 homes alone had a combined market value of over $30 million. And beyond the money, this was about principle. This was about my family's legacy. This was about justice. I turned down every offer. The trial began on a cold Monday morning in January of 2023. The courtroom was packed. Residents from Oakwood Estates filled the gallery. Reporters lined the back wall. Victor Hargrove sat at one table with his team of expensive attorneys. The HOA sat at another table with Richard Davenport. The county had its own legal team. And there I was, sitting next to Patricia Owens, with a folder containing a deed that was over 100 years old. Patricia's opening statement was masterful. She stood in front of the jury and spoke plainly. She told them the story of Elijah Mercer, a hard-working man who bought a piece of land in 1902 and dreamed of building something for his family. She told them about Thomas Mercer, who farmed the land for decades. She told them about my father, who kept paying the taxes even when he could not visit. And she told them about me, a man who drove 3 hours to check on his inheritance and found that it had been stolen. Ladies and gentlemen, she said, this is not a complicated case. A man's land was taken from him through fraud. We are here to make it right. Richard Davenport, the HOA's attorney, had a different approach. He tried to make it about the homeowners. He talked about families, children, stability. He argued that even if there were irregularities in the tax sale, the homeowners had purchased their properties in good faith and should be protected. He painted me as a man who was trying to destroy a community for personal gain. It was emotional. It was manipulative. And the jury saw right through it. The most powerful moment of the trial came when Patricia presented the original deed. She had it authenticated by a forensic document examiner who confirmed its age, the ink, the paper, and the signatures. She projected it on a large screen for the jury to see. Every word was legible. Every detail was clear. The property description matched the exact boundaries of the Oakwood Estates development. There was no ambiguity. There was no question. That land belonged to the Mercer family. It had always belonged to the Mercer family. Patricia then walked the jury through the chain of titles. From Elijah Mercer in 1902, to his son William in 1938, to Thomas Mercer in 1961, to my father Robert in 2004, to me in 2016. Every transfer was documented. Every deed was recorded. There were no gaps, no breaks, no irregularities. The chain of titles was unbroken for over 100 years, until Carl Jennings fabricated a tax lien and broke it. Next came the tax receipts. Patricia presented bank statements, canceled checks, and county receipts showing that my family had paid property taxes on the land every single year without interruption. She showed the jury the specific receipt for the year that Carl Jennings claimed the taxes were unpaid. The receipt was right there, stamped and dated. The taxes had been paid. The line was a lie. Then came the emails. Patricia read them aloud to the jury. In one email, Carl Jennings wrote to Victor Hargrove, I've identified a property in Harlow Creek, 147 acres, old family land. The owner lives out of state. Easy target. In another email, Hargrove replied, Perfect. File the line in Q4. We will have the sale wrapped up by spring. The jury members' faces changed as they listened. Some looked disgusted. Some looked angry. One woman on the jury shook her head slowly. These were not the communications of innocent men conducting legitimate business. These were the words of conspirators who knew exactly what they were doing. The whistleblower from the county assessor's office took the stand. Her name was Karen Delgado. She had worked under Carl Jennings for 7 years. She testified that Jennings had asked her to backdate documents related to the Mercer property. She refused. He told her that if she said anything, he would have her fired. She kept quiet out of fear, but saved copies of the original documents that showed the manipulation. When Patricia presented those documents to the jury, it was the final nail in the coffin. Carl Jennings was called as a witness. He had been advised by his attorney not to testify. But the judge compelled his testimony on certain matters related to his official duties. He was evasive. He was hostile. He tried to blame subordinates. He claimed he could not remember key details. But when Patricia confronted him with his own emails, his own handwriting on the fraudulent documents in Karen Delgado's testimony, he had nowhere to hide. At one point, he simply stopped answering questions and stared at the table in front of him. The judge had to instruct him to respond. Victor Hargrove took the stand next. He tried to maintain the fiction that he had purchased the land at a legitimate tax sale. But Patricia dismantled his story piece by piece. She showed that he had never conducted any due diligence on the property. He had never checked the chain of titles. He had never verified the legitimacy of the tax lien. He had simply relied on his friend Carl Jennings to hand him the land on a silver platter. When Patricia asked Mr. Hargrove, "Did you know that this land belonged to the Mercer family when you purchased it?" He paused for a long time before answering. "I relied on the county records." Patricia replied, "The records that your business partner fabricated." Hargrove's attorney objected, but the point had been made. The HOA president, a man named Greg Sutherland, also testified. He was not a villain. He was a retired school teacher who had bought a home in Oakwood Estates because he liked the neighborhood. He genuinely believed that the development was legitimate. When he was asked about the cease and desist letter that had been sent to me, he admitted that he had authorized it based on the advice of the HOA's attorney, Richard Davenport. He said he regretted it. He said he wished he had listened to me when I first reached out. For the first time during the trial, I felt sympathy for someone on the other side. Patricia's closing argument was short and powerful. She stood in front of the jury and said, "The evidence is overwhelming. A public official conspired with a private developer to steal land from a family that had owned it for over a century. They fabricated documents. They manipulated records. They erased a man's heritage and replaced it with a subdivision. Daniel Mercer is not the villain in this story. He is the victim, and it is up to you to make this right." Richard Davenport made an emotional plea for the homeowners, but even he seemed to know that the case was lost. His closing argument felt like a formality, not a conviction. The jury deliberated for less than 4 hours. In any case, this complex is incredibly fast. When they filed back into the courtroom, I could feel my heart pounding. Patricia squeezed my arm. The foreman stood and read the verdict. Guilty on all counts. The jury found that the tax lien was fraudulent. They found that the tax sale was invalid. They found that Ridgeline Development Group and Victor Hargrove had conspired with Carl Jennings to steal my property. They found that the county was negligent in failing to prevent the fraud. And they ruled that the Oakwood Estates development had been built on land that rightfully belonged to me. I sat there in silence as the verdict was read. Patricia was smiling. The Oakwood Estates residents were in shock. Victor Hargrove put his head in his hands. I felt 100 emotions at once: relief, vindication, grief, and overwhelming gratitude to my grandfather, who had always told me to never let anyone take the land. The jury awarded me $22 million in damages. That included the current market value of the land, the profits that Ridgeline Development Group had made from selling the homes, compensatory damages for the years of stress and hardship, and punitive damages for the egregious nature of the fraud. The county was held jointly liable for a portion of the damages due to their negligence. It was one of the largest property fraud verdicts in the state's history. Now, I know what you are thinking. What about the 96 families living in those homes? This is the part of the story that most people do not hear. I did not want those families to suffer. They were victims too. They had been sold homes on stolen land by people who knew the land was stolen. Under the court's ruling, the homeowners had valid claims against Ridgeline Development Group, Victor Hargrove, and their title insurance companies. Most of the homeowners were able to recover their investments through title insurance claims and lawsuits against Ridgeline. The court also established a process for the homeowners to negotiate long-term leases or purchase agreements directly with me for the land their homes sat on. I worked with each and every one of them. I offered fair terms. I did not gouge anyone. I did not evict anyone. These were families. They had children. They had lives. I was not going to destroy them the way Hargrove and Jennings had tried to destroy me. Carl Jennings was charged with multiple felonies, including fraud, conspiracy, and abuse of public office. He was convicted and sentenced to 8 years in prison. Victor Hargrove was charged with conspiracy and fraud. He pleaded guilty and received 6 years. His development company was dissolved and its assets were seized to help pay the judgment. Richard Davenport, the HOA's attorney, was investigated by the State Bar for his role in sending the CSAHN desist letter and making false public statements. He was ultimately censured, but not disbarred. In the months following the trial, I returned to Harlow Creek. I walked the streets of Oakwood Estates, the neighborhood that had been built on my family's land. It was strange. The land looked nothing like what I remembered. The fields were gone. The creek was buried under concrete. The old oak trees had been cut down. But the land was still mine, and the people living on it now knew the truth. Several of the homeowners came up to me and apologized for the way they had treated me. One woman brought me a pie and said she was sorry for the threatening phone call her husband had made. I accepted every apology with grace. I understood their fear. I had felt fear too, with the settlement money and the ongoing lease income from the homeowners. I was able to rebuild my family's legacy. I purchased an adjacent 30-acre parcel of land that had once been part of the original Mercer property. I built a new farmhouse on it, in the same style as my grandfather's. I planted oak trees. I restored a section of the creek to its natural course. And I put up a small memorial marker for Elijah Mercer, the man who had started it all. The marker reads, Elijah Mercer, 1868 to 1945. He bought this land with the sweat of his brow and the strength of his character. His legacy endures. If there is one thing I want you to take away from this story, it is this. Protect your property. Know what you own. Keep your documents safe. Pay your taxes and keep the receipts. Check your county records regularly. Do not assume that just because something belongs to you, it is safe. There are people out there who will take advantage of absentee landowners, especially families who have held property for generations. They count on you not paying attention. They count on you not fighting back. Do not give them that satisfaction. To the homeowners of Oakwood Estates, I want to say this. I never blamed you. You bought your homes in good faith. You were lied to, just like I was. The people who deserve the blame are the ones who orchestrated the fraud. Carl Jennings and Victor Hargrove chose greed over integrity, and they paid the price. I hope that we can continue to be good neighbors. I hope that the leases I have offered are fair and reasonable. And I hope that your children grow up on that land and feel the same connection to it that I feel. Because at the end of the day, land is not just dirt and grass. It is a memory. It is identity. It is home. I stood in that courtroom with a piece of paper that was over 100 years old. A deed. A simple document that said this land belongs to the Mercer family. And against all the power of a corrupt official, a greedy developer, an aggressive HOA, and an army of attorneys, that piece of paper won. Because the truth always wins. It might take time. It might take sacrifice. It might take every ounce of strength you have. But if you stand firm, if you refuse to back down, if you hold on to what is rightfully yours, the truth will prevail. My grandfather told me to never let anyone take the land. I kept my promise. And if you are out there right now, fighting a battle that seems impossible, I want you to know something. Do not give up. Your deed is your weapon. Your truth is your shield. And justice, no matter how long it takes, is always worth the fight. Thank you for listening to my story. If it moved you, please share it with someone who needs to hear it. And remember, always protect what is yours.